Pilot did a great job in New York. Called his mom. She was at luncheon. Don't worry, Mom. It's their
Code enforcement meeting will come to order. Bobby, would you read or call the roll, please?
Mr. Weeks?
Here.
Miss Wade?
Here.
Miss Dabbs?
Here.
Mr. Kramer?
Here.
Mr. Robinson?
Here.
Ms. Norfleet?
Here.
Mrs. Telliar?
here.
Mrs. Vacacy? Absent.
Thank
That
you.
completes your roll call, sir.
Thank you.
Mhm.
At this time, we're going to ask the board attorney to give us an invocation and then lead us in the Pledge of Allegiance. If you'll please stand.
Heavenly Father, we come humbly before you at a time of sorrow. The death of Jim Archer burdens our hearts, a burden shared throughout the city of Tarpon Springs. We pray that you will comfort Becky and welcome Jim into your heavenly kingdom. We are hopeful that your grace and love will be with the Archer family and those present here today who share in their pain and loss. This we pray. Amen.
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 I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
It's the intention of this board to promote and protect and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggravated party may appeal a final administrative order of this board to the circuit court to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings and to support such an appeal. Procedure of the board is as follows. First, the city presents its witnesses and experts, after which the alleged violator is able to ask the city witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits, and then the city can question the alleged violator's witnesses. After rounds of testimony, both of the part of the city and on the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of this case to discuss it and to take appropriate actions. Before we begin the public hearings, we will have all potential witnesses stand now and be sworn in by the secretary of the board, if you will.
Anyone that's going to speak today, stand up, raise your right hand, be sworn under oath.
Do you swear the testimony you're about to give us the whole truth and nothing but the truth?
I do.
Thank you. Seated.
First case we're going to have today is out of order. It's number 15, the motion to amend Board Order 18-800000141 at 457 East Morgan Street. Ms. Cross. Ms. Cross, would you like to come up to the... Is that what we want to do?
It's fine. The city's just requesting, there was a discrepancy with the parcel number.
Right.
So the original board order had the wrong parcel number. We're requesting that the order be corrected with the correct parcel number. And she's the owner of the property, and that's why she's here.
Okay. And so what is the proper order?
I'm sorry?
What is the proper number on the
The correct parcel number is 132715-64944-000-0100. All the previous notices went to the correct property owner. They just had a discrepancy in the parcel number on there, and it resulted in some paperwork problems. So we're requesting that that record be corrected, so the board would have to do an order to change that parcel number, so a new order could be issued with the correct parcel number. So it's basically quashing the previous order, I believe.
Just amending it.
Amending it, sorry, we're just amending the previous order.
I move,
Yes, go ahead.
I move that we amend the previous order and designate the correct parcel number, and the findings of the board stand.
It's seconded, and motion discussion. Okay. I think we need a hand vote.
No, roll call vote.
Roll call vote, please.
Mrs. Telliar?
Yes.
No, I'm sorry. We have a full house, I apologize. Sorry about that. Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Yes. Ms. Wade?
Yes.
Mr. Weeks?
Yes. Motion carries.
Mr. Chairman, just the paperwork is coming down through the board right now.
Thank you.
Okay, you're done, ma'am. Thank you.
Thanks,
The
Ms.
order will
Ross.
Thanks.
I hope you get to work on time. Yeah,
Yes, ma'am.
no worries. Appreciate you being there. New business, 19-800000477, and this one is to be established. This is 1008 Coldstream Court. David and Tammy. I can't pronounce your last name. Lars. Have a seat, sir.
We need to find out his name and address.
Your name and address, sir, if you'll speak into the microphone.
David Flars, 1008 Coldstream Court, Tarpon Springs.
Thank you. First, the city will present its case, and then you'll have a time to respond. Go ahead.
He's got the current pictures. I want to make sure you had no objection to any of those before we.
Do you have any objections to the evidence as it?
The first picture, the Altima vehicle was never unregistered, was never uninsured.
Okay, we're not going to go through the testimony right now. The question is do you have a legal objection to those items coming into evidence? If not, you'll have the opportunity to discuss all of that in just a few minutes.
Okay.
No objections to the photographs? Okay.
Go ahead.
All right, thank you. Thank you. This is case number 19-800000477. The property address is 1008 Coldstream Court. Property owner is David and Tammy Fallars. I'm Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Exhibit number 1 going before the board are all my photographs that were taken. Exhibit number 2, all of the notices of violation and notice of hearing. Exhibit number 3 going before the board are administrative documents, case summary, property appraiser, and tax collector records. And exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All of my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent both return receipt request as well as first-class mail. And Mr. Chairman, please accept all these exhibits into the record as evidence.
Bobby, will you please take them into?
Yes, sir, I will accept.
Thank you.
Received.
Our office has had contact with the owner via phone. The original case started on July 12th of this year when I conducted the initial inspection. The complaint was regarding cars with no tags. When I conducted my inspection, there were 3 vehicles on the property. A Jeep SUV backed in, appears to be inoperative. A white Ford Expedition with Florida tag 0130QK. Those tags were expired August 1st of 2015. A black Nissan with Florida tag JZRD28 that had expired tags of 7/4/2019. There was trash and debris on the property. There was a broken front window and another window that was boarded up. On July 15th, the notice of violation was mailed. It was returned unclaimed. On August 9th, I conducted a reinspection. The window in front had not yet been repaired. The trash was cleaned up, so that was put into compliance. The white Ford was still there with expired tags, and the other vehicles had been removed. On August 12th of this year, the notice of hearing was mailed. It was the mail was returned to the office. On August 30th, I posted the property and signed the affidavit of posting. And on September 12th, I conducted an inspection. It is in compliance. It looks like a shelter of some sort was put up, kind of a canvas. Looks like a car might be in it, but I can't be for sure. It's not an enclosed structure. And the white Ford, that was the last of the vehicles that were in violation, was gone. And the broken front window had been repaired. So as of this time, all of the violations before the city are in compliance, but I am wishing to establish them for violation of City Code 8-22, which is the accumulation of trash, 8-40, the duty to maintain private property, 8-52, nuisance prohibitions, primarily overgrown debris, things like that, 40.00, which deals with the parking storage of abandoned vehicles, which also includes vehicles with expired tags, and international property, well, actually the adoption of City Code 6-1, which adopts the 2018 version of International Property Maintenance Code. And under that section of IPMC 30413, which is windows and door frames, deals with you have to have the proper glazing material, your windows have to function, those kind of things. And as I stated, they're all currently in compliance, and I'm just wishing the board to establish those violations.
David, you now have the opportunity to question the officer in reference to the evidence that he stated.
Okay. First off, the,
Questions?
Questions?
okay, on the broken window.
Yes.
Apparently, you guys, from what I understood, send out a notice in July, which I did not receive. I received the notice in August. I contacted your office, or in August. I left, I believe it was 3 messages. I believe I talked to your secretary. She informed me that an issue was sent out in July. When it comes to the window was repaired in July. In August, you apparently cited that again as being broken. And I'm assuming you're referring to the window that is boarded?
The code, yes, it's 2 parts to that. That section of the International Property Maintenance Code has like 4 sentences in it, and I'll read it to you just so you understand, but we did send it to you. Okay. So it did deal with every window other than fixed windows shall be easily openable and capable of being maintained in a position by window hardware. That's under that section as well. So yes, you did fix the glazing material on the window, which would be to the left looking at the house, but then the other window still had some sort of structure that appears to be boarded up or not in a operable position, and I can actually bring a picture of that up. That's with it broken, so there's boards on it. And then there's, let me bring it over to the screen, hang on, gotta move it. So that was July 12th, that was the initial inspection. And then when I went back and put the broken window in compliance, I have to move it over there, so stand by just a second. That window was fixed, so what was left was basically the same material this was here on the other window. And I do understand you stated it was to prevent a dog or whatever the case may be from getting out. Unfortunately, and it is in compliance. I put it in compliance based on what you stated, but if there ends up, we'll establish it for any previous or any future violations. So I don't argue the fact that it's in compliance.
All right,
Just as you stated, it's all in compliance, so it's fixed.
Because I'm understanding, if I'm understanding this correct, you've got the window as being broken. The window is never broken except for the pane to the left.
Okay.
The dog did break that window and it was taped. The window to the right was never broken. That is basically barricaded because my dog is smart enough to unlock the window, open the window, and jump out. And there was issues to where the county was coming in because the dog kept on getting out. That is the only way to keep it from the dog opening the window and getting.
Okay, so the window was broken,
The window was never broken.
the one with the tape.
The one with the tape was, and that was replaced.
Okay, so it was fixed.
Yeah,
So it's in
that-
compliance.
Right, but in August,
Okay.
you still cited that when it was already fixed in
Yeah,
August.
for this part.
That window was never broken.
Okay, but I read you the code that says openable windows. Every window other than a fixed window shall be easily openable and capable of being held in a position by window hardware. So when I conducted that reinspection, It appears that this can't be opened. I'm just hedging my bets that 3 bars being bolted into the window frame and into the window itself pretty much means it can't be opened. You explained it, that you have a dog issue, so I complied it. Okay? Because that was reasonable. It's not exactly proper, and it's probably not the best way, but by the lesser of two evils, having your dog get out, bite somebody, or whatever the case may be, we complied that. The window was fixed, and we complied it. It's still not the preferred method, but it's better than the alternative. So that's why we complied it after you explained the reason why that was done. So, and you're correct. From what you state, it's not broken behind it, but it is not openable. So it still technically is a violation. So that probably still needs to be addressed, but the city's not going to pursue a case for that aspect of it.
Okay.
But in the future, if you have another broken window, that's where this becomes an issue.
Now going into regards of the Expedition, the white Expedition. That is a vehicle that my son has, who is currently overseas in South Korea serving. I don't, the vehicle is maintained, it was kept clean, it wasn't a nuisance. If I put gas in it and the battery hooked back up to it, it's operable. It was parked on my driveway. Why is that an issue?
Because the city code requires that the tags also be current. It's a requirement of the code that both the vehicle both be operable and have current valid registration.
Isn't that kind of a, I don't want to say nuisance, but isn't it that kind of a little ridiculous? Forcing me to place insurance on a vehicle that's not even being driven?
Sir, I don't make the codes, I just enforce the codes. And the logic behind them, I can't necessarily tell you the reason, probably because I have no earthly idea why, but that's what the code says and that's what I enforce. So, and like in the picture, and I ran the tag again, for what it's worth from where it was parked before, it was very easy for me to see the tag, and then somebody made an effort to back it up very close to a trailer, probably an attempt to cover that up. That's my opinion. Because you could see what I was able to get with a zoom camera was I was still able to see the tag was expired later on. And then it's been moved, and I assume it's probably underneath that canopy or whatever. And if that is the case, it's still technically a violation, but I can't see what's inside of it, so the vehicle's not there. But if it is in there, it's not an enclosed structure, and it is still technically a violation. So if that thing comes apart and the vehicle's there, unfortunately, you're going to still be in violation of that code. That's all I can tell you is it requires those two things, operable and current tags. So I know the state will allow you to suspend the registration on a vehicle, but that's something you'll have to bring up with DHS&V. There may even be certain circumstances for having deployed troops, because there's a lot of allowances for that, but this is the first I've heard of that. So you could address that at a different point. But I put it into compliance, so it's only moving forward that it's an issue.
Going into the picture with the limbs, the branch,
The which one?
the picture with the branches against the fence.
Correct. I'm getting there. Hang on.
Could you take the microphone and take it a little bit closer? Thanks.
Now, when I trim my trees and stuff, how much time do I have to get rid of the stuff?
You're in compliance. You got rid of it within the prescribed period of time, and you're in compliance. I'm just establishing it. It's a broad definition of debris, which was included with your notice of violation. It encompasses a lot of things. The tree branches were only one aspect of that. I believe you had a bunch of stuff kind of now where that canopy is that looked like it might have been unused equipment or things like that. So as I stated, debris is a very broad subject, or a broad definition of multiple things. So it wasn't just the tree branches, but the trash, I believe they pick up tree branches every Monday, as long as they're bundled up correctly. So it's kind of reasonable to think if you cut them down on Sunday, if they're out at the curb tied up and ready to go, I'm not going to violate you for that. Based on the way those looked, I'm not an arborist. She's sitting behind me, but I'm thinking they were cut down more than the day before, just because of their color and everything. So, but again, you're in compliance with that as well. You are not in violation of any city code at this moment in time.
I'm
aware of.
I'm just trying to establish why I was written up for these things, placed in violation.
Well, even debris is actually defined as well as inoperable vehicles, boats, trailers, things like that. So we have not only 40.00 for unregistered vehicles, this is also considered debris under the city code. You know, the radiator sitting on top of it, yes, it's gone, I understand that. So it's kind of all of those things, not necessarily just one thing. I took a photograph of multiple things, and this can as well be considered debris. I believe you cleaned all this stuff up over here on the side. I can't remember if this trailer was yours or not. So, okay. But that's also debris under the definition. So not only the tree branches, but this as well.
Do you want to go ahead with your case, or do you have anything else you want to submit?
No, that's how it covers it. I mean,
Okay.
the only issue, like I said, is the expedition is when my son comes back. I currently have, there's 4 vehicles. I have the Jeep that I drive, the black car that my wife drives, which are both registered, insured continuously. I have another vehicle in Washington State when my son's over there based, and the expedition when he comes here that he drives.
You understand it's just being established. That
Yeah, I don't understand quite what that means.
could you explain what established means? For this?
Basically, if the board finds that there was a violation at that time, what happens is if there, for the next period of 5 years, if there's another violation, you won't necessarily get a notice of violation the same way. Fines can immediately start that day. So basically, it becomes your responsibility to make sure none of those violations occur for the next 5 years. So that's because then technically you become what's called a repeat violator. So as of right now, there's no fines or anything like that. It's kind of putting you on notice that moving forward, you have to be very diligent about taking care of your property so that you don't end up getting fines up to $500 a day. So that's what establishing does.
Does the board have any questions for either the city or the respondent?
I move based on the testimony, evidence, facts presented in the law that at the time of the alleged violation, sections 40.00, 6.1 of the building code, and IPMC code 304.13 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. And at the time of the notice of violation, the respondents were in violation of said code sections. However, they are now in compliance.
Second.
Seconded.
I have a question.
Go.
The officer also mentioned 8-22, 8-40, and 8-52. Do they need to be in the motion?
The answer is yes. If you found that there was a violation of those code sections that were not brought into compliance within the time demanded by the notice of violation, then they would also be included in your motion.
You mentioned those 3.
I did mention those. They were brought into compliance. Looking back through the paperwork, they were brought into compliance in the time that was prescribed. So right now, the motion would be correct, and I would agree with those 3 violations.
Roll call, Bobby?
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs, Ms. Wade,
Yes.
Mr. Weeks.
Yes.
Motion carries.
You want me to summarize that?
You didn't call one person?
No.
He doesn't vote at this
Oh, yeah.
time, I'm sorry.
Oh, excuse me.
Mr. Our attorney will summarize what's going on for you so that you can a little bit.
Sir, you've been found that in violation of code sections 40.006-1 and IPMC, which is International Property Maintenance Code, section 304.13. There will be an order entered reflecting that in the next 10 days. It'll be provided to you at the same address listed by the property appraiser and tax collector's office. If you're found to be in violation of those 3 code sections, again, in the next 5 years, you'll be deemed a repeat violator as mentioned by Officer Gasson. So it's very important that you make sure that you're in compliance at all times. There are no fines associated there are no prosecution costs associated with this. So if you stay and maintain compliance, there will be no other issues, at least for the next 5 years on your property. Okay? Thank you.
Thank your son for his service. Number 3, repeat violator 19-800000548, 1702 Mexico Avenue. Cristo,
They're not here.
city, please.
This is case number 19-800000548. The property address is 1702 Mexico Avenue. The violator of record is Janesse Andres and William Prieto. This is a repeat violator case for case number 18-800000573, which was found in violation of section 13302. On that case, it was complied before the $25 a day fine could start, yet the prosecution costs of $167.50 are still owed. I'm Shannon Brewer. I'm currently employed by the City of Tarpon Springs. I'm an ISA certified arborist. My license number is FL-9221-A. I'm also an FNLGA certified horticultural professional license number H978402. Exhibit 1 for you today will be all my photos. Exhibit 2 is the notices to include the NOV and NOHs. Exhibit 3 is my admin docs to include the case summary, previous board orders, and property appraiser and tax collector records. Exhibit 4 is the affidavit of posting and a copy of the sign. Exhibit 5 is the affidavit of prosecution costs. All the notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and the tax collector database. All the NOVs and NOHs were sent return receipt requested and first-class mail. Please accept all of these exhibits into record as evidence.
Bobby, when it gets down to you, please accept them into evidence.
Yes, sir.
You have a story?
Yes, you ready? Okay. This case, like I said, is to establish a repeat violator. The first case came from November of 2018. Dead trees were cited by the code board. At that time, the tree that's under consideration today was alive. As of the end of July 2019, a citizen complaint came into the office stating a dead pine was behind the home at 1702 Mexico Avenue. Upon inspection, August 5th, I confirmed the complaint. Exhibit 1 for you, my photographs, were taken by me and was a fair and accurate representation of the condition of the property when I took that photo. The large main leader had snapped out of the tree, causing the top to be very top-heavy on one side. The bark appeared to be falling off the remaining branches, which would have been the canopy of the tree. The property was out of compliance of Ordinance 13302 due to the dead tree being hazardous to persons and property. Since this is a repeat violator, the repeat violator notice of hearing was sent out that day. August 29th, the property was posted and the affidavit of posting was signed. August 30th, a phone call was received from the owner, Ms. Andres, inquiring if a permit would be required for removal of the dead tree. Under the new Florida statute 163.045, a permit was not required since I am an arborist, and my notice did state that the tree was hazardous. On September 10th, the email was received from the owner stating the tree was removed. The next morning, I inspected and confirmed the removal was complete and the property was in compliance, or is now in compliance. Just to recap, the initial inspection was conducted 8/5. The property is in compliance as of 9/11/19. The board has been provided an email from the owner giving the reason why the owner is not present, because she does not live in Tarpon. I have nothing further at this time.
Board have any questions?
So do we feel that it was out of compliance from July 5th of?
August
August.
August 5th.
August 5th
Correct.
to September 11th?
Correct.
And we had previously issued a $25 a day fine?
Correct.
Thank you.
I have a question. I just want to make, for clarity's sake, you said that they contacted you on September 10th and told you they were in compliance.
Yes, because it was a very late email in the afternoon, and I was not at work. The next morning, when I opened up the email, I went out immediately.
Okay.
Okay, so you did your reinspection on the 11th, but the property was in compliance on the 10th.
Okay.
Yeah,
I
is that
didn't know how
correct?
that would be actually be,
Okay.
okay.
Thank
I
you.
just want to make sure that they have the correct dates. Okay,
But I did actually inspect them.
gotcha.
I have a question about that. If
Oh, that is true. I did actually went to, on the 10th in the morning of, for a reinspection as in preparation of this. And then they must have done the work that afternoon because I went out very early in the morning on the 10th. So it was done on the 10th. And then the email came in. I was not at the job because it was after hours. And then on the 11th morning of, very early, I went and I did my reinspection.
I have a question. When you do the reinspection, is that when it's in compliance, or is it when somebody calls on an email and tells you?
When
that
they
they're in
notify me.
compliance?
When they notify me, that becomes compliant.
Okay.
I had one other question. The affidavit of prosecution cost listed as $64.50, but you mentioned $167.50.
That there was a previous case has the 167.50.
That has not been satisfied,
Correct.
and additionally, there's $64.50
For this case,
for this
correct.
time. Thank you.
Okay. I'll entertain a motion. It's okay.
I move based on the testimony, evidence, facts presented in law that the respondent was in violation of section 133.02 of the Tarpon Springs City Code from August 5th of 2019 to December 10th of 2019.
You mean
September, thank you, September 10th of 2019. And a fine of $25 per day for 35 days. And that total fine would be $350. In addition, I move that the city be awarded $132 in prosecution costs, which reflects, $232 in prosecution costs, which reflects the previous amount owed and the additional amount.
All right, before you have that second on that motion, there is no evidence in this case that they've incurred $232 in prosecution costs in this case. The evidence is that they incurred $64.50 worth of prosecution costs. The prosecution costs in the prior case would have been included in the prior order. So it would be a duplicative prosecution cost. So I would caution you to only assess the $64.50 that is currently being testified to in affidavit form.
I'll amend my motion to reflect that. Thank you.
Okay.
A second, please. Anybody? Thank you. Roll call. Bobby?
Yes, sir. Mrs. Telliar?
You have to vote. Okay.
Yes. Thank you. Mrs. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Miss Wade?
Yes.
Mr. Weeks?
Yes.
Motion carried.
Repeat violator 19-8000555, 201 North Pinellas Avenue. Harry
Katsoulides.
Pasolidis. Thank you.
Ready?
And you are.
I think he's been provided with evidence.
Mr. Patzlides, any objection to the or to the photographs being presented by the city?
Not to the photograph, but some of the other items.
Okay, why don't you tell the board what your legal objection is to the other items then, so we can try to address those?
I'm questioning the accuracy of
Okay, so you'll be
several.
able to
There
have
are
the opportunity.
several.
I'm sorry, I don't mean to keep interrupting you, but if it is that you dispute what they say, well, then you have the opportunity to cross-examine on that. But I'm looking for is whether or not there are any legal objections like relevancy, hearsay, authentication, those types of legal arguments.
The objection would be to the dates listed and the accuracy of the information in some of the other exhibits. And also in that I received stuff today that I didn't receive initially in the violation package. So I've got new information here that I didn't get when they sent the violation out.
Okay, so I guess we'll just go ahead and proceed. And then when you get to the point where you want to submit whatever into evidence, then the board chair can make a decision as to how he wants to rule on each one of those.
Understood.
No objection to the photographs. You could do that when they come through.
Okay. Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case before the board is case number 19-800000555. The property address is 201 North Pinellas Avenue, owned by Harry and Anna Patzalidis. This is a repeat violator case, and there's a few prior cases that establish it as such. Starting out with case number 19-800000484, which was for a violation of City Code 8-40 and 8-52. At that time, this board found a fine of $75 per day, and as of September 10th, that fine is $4,354.50, and it is still not in compliance. Another repeat violator case is 19-800000396. It also is for City Codes 8-40 and 8-52. That was also $75 per day for a total of $2,584, also not paid. Repeat violator for case number 18-800000692. That was a violation of City Codes 8-40, 6-1, 13302, 36.03, and IPMC 302.7. That was $25 per day for a total of $366, also not paid. The last one is a repeat violator, case number 16-800000387. It was also a violation of City Code 8-40, 9-1, and IPMC 303.1. That one was simply established, and there was no fines assessed. Exhibit number 1 going before the board are all of my photos. Exhibit number 2 are all my notices to include the notice of violation and notice of hearings. Exhibit number 3, administrative documents, case summary, previous board orders, and property appraiser and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. This case, and I'm sorry, all the photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All the notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent both return receipt requested as well as first-class mail. And Mr. Chairman, please accept all these exhibits into the record as evidence.
Okay.
Bobby, please do.
So let me just stop you right there. So the photographs, there's no objection to.
Right.
Those should be moved along. As to the other evidence, Mr. Patzalidis has made some arguments, and I just want to address them to help you. So dates and accuracy of the documents themselves, that is not an appropriate legal objection. He can cross-examine on those and testify as to what the correct dates are and the accuracy or inaccuracy of those are. As for the late receipt of the evidence, although that may be a strong argument, because he has not had the opportunity to review them, we can give him as much time as possible to review them now if he wants. But my advice to you is to go ahead and receive both of those into evidence over the objection of Mr. Patzalidis, because those are not true legal objections. So, but it's your decision in your entirety. It's not a board decision, Mr. Chairman.
Go ahead and accept them into evidence, please, Bobby.
We're moving forward. Okay. We have had contact with the owner. He's contacted the office via email. This case started out On my initial inspection on August 9th, there was a large amount of trash and debris on the south side of the building near the dumpster. You can see in the photograph on the board, which also went around. 201 North Pinellas is kind of an interesting address. It actually has two separate buildings on it. This is the building that's behind the main one that's actually on Pinellas Avenue, but they are all the same parcel. So this was called in by the city from the Waste Management Division. They apparently got a complaint from Waste Management because Waste Management was unable to pick up the trash. They contacted the city contacted me. I started a case on it. Let me pull up my notes here really quick on this. It was originally put in on August 7th. I think that's when the original case was called into the office. I didn't conduct the inspection until, as I testified, August 9th. And as I found a large amount of trash and debris on the south side of the building. On August 12th, the notice of violation, notice of hearing, and a repeat violation notice of hearing were mailed. The green card was returned signed. The inspection was conducted on Friday. Mail had already gone out when the clerk got email to send the repeat violator notice, hence the weekend delay. On August 27th, I conducted a reinspection, and it was in compliance. We used the date of August 16th because the property owner requested a reinspection on that date and stated it was in compliance. So I conducted the inspection on August 27th, found that it was in compliance. So the period of time it was out of compliance was from August 9th until August 16th. Posted the property on August 30th and signed the affidavit of posting. So we find that it is in violation for a repeat violator from the date of the initial inspection on August 9th until it was complied on August 16th. And it was for violations of City Code 8-22, accumulation of trash, 8-40, duty to maintain private property, and 8-52, which primarily dealt with debris. And at this point, that's all the city has.
Pasalinas. I have a hard time with your name. I
Harry.
apologize. I really do.
Patsalides.
Pasalinas.
Yes, sir.
Do you have any questions for Officer Gasson?
Yes, sir, I do.
Go ahead.
Okay. I don't know if this is an appropriate question to ask regarding the exhibits right now.
Just
But-
questions, yeah.
Yeah, the exhibit I got today shows the complaint, as Officer Gasson just stated, that it was submitted, I guess, from Waste Management. However, the complaint that I received originally does not have any of that information in it at all. It just says that,
Is that a question?
yeah, I just wanted to know why the disconnect between.
There's no disconnect, sir.
He gets
He
to
would
answer it. Yeah, he gets to ask that question now. So, yeah.
Many people call in complaints. By state law, I have to witness the complaint. Therefore, the violation is me witnessing it. The complaint from city crew or whatever stating there was trash was 2 days previously. I went out and saw that their complaint was in fact true. So it's not a disconnect. I'm the one issuing the notice. Is that what you're asking?
I'm not asking that, and
Okay.
I agree with what you're saying.
Okay.
I'm saying that in the information I got in Exhibit 3, it didn't state anything about the complaint being filed. There was no information regarding the complaint.
Did you get a
and where
history?
it
It
came
looks like
from.
this.
Pardon me?
Did you get a history? It looks like this. It's a horizontal copy. It says Exhibit 3 on it.
Yes.
Okay.
Currently, but the one that I got originally is not like that.
We don't typically, based on some of your previous cases, we decided to start giving people this information. So this is kind of at your request. It's not sent out in the mail unless you ask for a history. Huh? Okay. What are we're still working on what we're asking. Okay.
No, I'm not talking about that. I can find. Wait a minute. No, that's what I got today.
Fortunately, for some reason, I did not bring that with me today. But is this what you're calling history?
Yeah, we
Okay, I didn't get that.
yeah, you don't. You asked for.
Okay,
That's the first.
okay, thank you. Okay, Officer Gasson, let's start with the pictures. I think you identified, I think in the complaint here, that it says, well, is there something painted on the walls of the building there?
Mm-hmm.
What's on there?
No dumping, no parking, REL, auto, something custom.
Right. I was talking about the no dumping and no
Oh, okay.
parking. And is there something painted on the dumpster as well?
I don't know.
Okay.
I don't have a picture of the dumpster itself, I believe.
All right. I'd like to submit as I can't do the exhibits yet, or
No, you need to finish your cross-examination, then we'll get into your case.
okay.
Oh, yeah. Actually, it says no dumping on the dumpster. Sorry. Right there.
Good. So, why would you think I would paint those things on the building and on the dumpster?
I don't know if you painted them on there. They could have been there before you owned it.
Okay.
And the dumpster's a waste management.
Do you
dumpster.
experience people illegally dumping items on other people's property?
Yes.
Okay. Is there a dumpster on the property?
Yes, sir.
So, what is the appropriate procedure when somebody dumps something on somebody else's property? What is the property owner's obligation and the procedure that they have to follow?
Clean it up.
How?
Maybe I can give you a myriad of different reasons.
Just give me a couple, please.
Any particular ones, like hire somebody to remove it, take a pickup truck, throw it in the back of the pickup truck, take it to the dump,
Okay, that's good.
put it in the dumpster. I don't know.
Good. That's
Okay.
good. That's what the question was. Can I hire somebody to haul this stuff away?
I believe you could, yes.
That's not correct.
Wait, it's not.
No,
Okay.
sir. The only, excuse me, I'm asking you questions.
Oh,
I'm
sorry.
sorry. All right, let me ask you a question. Do you know that the city is the only person that may collect and dispose of the trash?
Well, it's more than a yes or no question. So if you'd like the explanation, I can give you that as well as the answer.
Do you know that only the city can collect and dispose of trash within the city? Yes or no?
Again, Mr.
Just a
Chairman,
yes or
it
no
poses
question.
for explanation, but I will say
I don't need an explanation. I
there
just
is a
need
city
yes or
ordinance
no.
that says yes.
Pardon me?
There is a city ordinance that says yes. That
Only the
only
city
waste
can
management
collect
can
trash,
collect
right?
trash, correct.
So that disagrees with what you just said about hiring some outside person to collect it. Am I correct?
I'm going to stop this line of questioning. This is getting us nowhere.
No, sir. It's the basis of my defense.
It's not getting us anywhere as it relates to these repeat violations. It's not getting us anywhere as it relates to the garbage that's on your property.
Yes, it does, sir.
Well, I'm
So
still gonna
let me
stop
ask the
it,
question
because I'm-
again. Is the procedure to call the city and ask for additional pickup to remove the trash?
I honestly don't know because I don't work in the
Okay.
Waste Management Division.
Sir, I am going to stop this line of questioning. If you have any other questions without answers and rebuttals, please do them now.
Well,
Questions
I-
only.
yeah, that was a
No
question.
rebuttal.
Okay,
Rebuttal.
excuse me. How did you determine I was not following the proper procedures in removing the trash?
Because it was stacked up outside of your property that you own and not disposed of properly, and Waste Management was the entity that notified us of the violation.
Okay, you stated that I violated 8-22.
Correct.
Does this section state it is unlawful for any person to permit or allow? And I've got the entire section, but I did not permit or allow this trash to accumulate on the property.
Well, it's there, so it's allowed.
Right,
And
but
you
the
own it.
violation says permit or allow.
So
All right,
you may not
do
have
you
permitted it,
believe-
but you allowed it.
Do you believe that I permitted or allowed someone to dump their trash on my property?
I don't think that's what it says. It doesn't say about littering. It says you're responsible. It says it shall be unlawful for any person to permit or allow any of the debris, trash, or rubbish mentioned in 8-21 to accumulate or remain upon the property located. So I believe you allowed it to accumulate and or remain because it clearly was there and it was remaining.
Okay.
So yes, I believe you violated that city ordinance.
All right, thank you.
And it's hazardous to the health and safety of any of the inhabitants of the city, which is also included in that ordinance.
All right, you also charged with 8-40.
Correct.
Please tell me specifically how this is a violation of 840.
It's a
duty
public nuisance.
To maintain maintenance of private property.
Well, 8-40, since you're,
And exactly
fairly
what
school.
section of that 8-40 you were referring to when you issued that code violation?
8-40 encompasses 8-38. The definitions of 8-38 include nuisances, injures, endangers the comfort, repose, health, or safety of others, unlawfully interferes with, obstructs, or tends to obstruct, or renders dangerous for passage in any public or private street, highway, sidewalk, stream, ditch, or drainage, in any way renders other persons insecure in life or the use of their property, or essentially interferes with the comfortable enjoyment of life and property, or tends to depreciate the value of the property of others. So 8-40 says that if you do anything in 838, which I think we could broadly stroke that if I was across the street trying to sell my house, I'd probably have a harder time doing it based on that violation. So that's what 840 encompasses.
Yeah. Does the furniture there, is that what's depicted in this picture? Is that furniture? Items?
Well, it's the trash and debris. There's a lot more than just furniture, I think.
Okay, you also charged,
852.
yes, sir.
Which definition would you like?
So please tell me specifically which part of 852 relates to the furniture being there? Or the
okay.
trash?
Well, it has to do with debris. So the definition of debris under 851, which 852 encompasses, abandoned, inoperable, or unusable material. We can probably stop there, but if you'd like, I'll keep going. Equipment or other machinery or other material, equipment or machinery which is stored externally, or other material, equipment, or machinery that is stored or maintained in such a fashion so as to create a nuisance as described in 850. And if you'd like, I can get to that.
No, that's
This-
good. That's
okay.
good, sir.
Okay.
Okay, that also says permit or allow any of this to accumulate, doesn't it?
Okay, yes.
Okay. So do you think I permitted this or allowed this to happen?
Yes.
Okay. Okay, in your listing here, you claim that this property had been previously established as a repeat violator on 8/8/2019 under case number 19-8000484. Is that correct?
No, you were established as a repeat violator, not the property. That was from Whitcomb.
I'm reading the wording in the
Okay.
exhibit. It says this property
Exhibit
was
are you looking at?
previously established.
Which exhibit are you looking at? So I can look at it.
Oh, I did find what I was looking for before.
If you're referring to the notice of hearing for the repeat violator where it says the property has been previously established as a repeat violator by the code board for those case numbers, is that what you're referring to?
I'm referring to the notice of hearing, repeat violator, dated August the 12th. And it says that this property has been previously established as a repeat violator. And and the first time it's listed, it refers to a date of August the 8th, 2019. Is that true?
Yes.
Was this property here previously established as a repeat violator?
The property was established as a repeat violator by nature of your ownership, according to Florida statute.
It doesn't say that. It says
No?
this
Florida
property.
statute does, though.
It says this property.
Okay.
was
Florida
previously
statute states
established.
that you are the owner of the property and therefore a repeat violator. And if you need any clarification on that, I can certainly pull the statute up or let the city attorney explain that.
Yes, please. I'd like that later. Thank you.
You're pretty confident you know 162, right? Florida state statute? Because we've discussed this many, many times before in a code board hearing.
Okay. The next one says the same thing. It says this property has been previously established, and it says on July 11th, 2019.
Right. I'll make it easy for all of them. All four of them will say that. You are the owner of all four of those properties, and therefore you, Harry Patsalides, are a repeat violator by nature of the fact that you own these properties.
It doesn't say that I'm
You're
a
absolutely right.
repeat
It
violator.
doesn't, but that is the
says
law, though.
That this property is.
So
And
it is.
My concern,
Gentlemen, please.
Okay.
is that you're prejudicing the code board, or are you prejudicing the code board
Sir,
by listing
if you
these
can't
violations?
do this the way we asked you to do it, I'm going to have to ask you to be removed. Now, I'm asking you to do questions and questions only now,
I
and
asked
not
a
to have
question.
a match. Who's got what? Please, questions only.
To answer your question, no, I'm not prejudicing the board in any way, shape, or form because you are the property owner and you have been established as a repeat violator. So yes, the notice of hearing repeat violator says the property has been previously established. That's because of your ownership of that property. So that is a true statement.
Okay. Is it true, the third one down, that it says this property has been previously established on October 11th, 2019? Is that a true statement?
It's a written statement, but it can't be a true statement since that date doesn't exist. It's a typo. It's supposed to be 2018. This was another one that you brought up in a previous issue. It's a typographical error for the previous year. That's all. If you'd like, I
So
do
you-
have, I'm
and the-
sorry, go ahead.
Pardon me?
I was going to offer you Florida State statute definition of a repeat violator for clarification if you'd like it.
Yes, sir.
Okay, Florida State Statute 316, or I'm sorry, 16204, subsection 5 states, a repeat violation means a violation of a provision of a code or ordinance by a person who has been previously found through a code enforcement board or any other quasi-judicial or judicial process to have violated or who has admitted violating the same provisions within 5 years prior to the violation, notwithstanding the violations occur at different locations, notwithstanding that they occurred at different locations.
I understand that,
Okay.
but I don't, still have my question for you as it relates to this property. Okay, you also list some additional violations here under these, this 10/11/2019, October 11th, 2019. You list 6.1, 133.02, 36.03, and 302.7. What are these?
They're for a different property. They were violations
What are
under
the
that case.
violations? What do they refer to?
They're not relevant to this case, sir. So I would object to that question, not for relevance.
And
Okay, in your Exhibit 4,
Which one? Hold on. I'm getting there. Okay, Exhibit 4.
okay, it states that you posted the property on August the 30th, 2019,
Correct.
and then in your Exhibit 5,
The prosecution costs?
Yes,
Or
sir.
Yes, sir.
okay, that's an affidavit,
Yes, it is.
and it states that you incurred costs for posting the sign, but the date is August the 12th, which is substantially before
Yes,
the date you actually carried out the posting and incurred the costs.
correct.
Isn't that a false statement?
Did I post the property on August 30th?
No, that
didn't?
you incurred cost of
Mm, yes,
posting
we
the
did, because we
property
had to-
on
yeah.
August the 12th.
Yes, we
when
did
you
incur
didn't
that
post
cost.
it and incur the cost until August the 30th.
Yes. What does that line item state? It states the sign is $5, I think, something to that effect. We incurred that cost because we made your sign on that date.
So you presumed I was guilty before anything was done, before we came here.
If it wasn't a repeat violator, which by law we have to post, that fact doesn't change. We were posting that property regardless. If it was a new violation, first time you had a violation and you came into compliance, we wouldn't be here and there wouldn't be an affidavit of cost.
This is a technical question. How can you swear under oath that you incurred a cost for posting a sign when you, on August the 12th, when you didn't post it until August the 30th?
Because I wouldn't be here if I didn't do it, nor would you. So yes, it's a very simple thing. When we make the sign, I swear out the affidavit that yes, I'm posting on August 30th. If I didn't, a new affidavit would have been completed. We have it scheduled when it's going to occur, and I swear that that's when it's going to occur. And it did occur on that date. And yes, it was on August 12th because that's when we incurred the cost of your sign. So that's a true statement.
But it says you didn't receive the sign till substantially later.
I didn't post it.
No, it says,
We owned it, we paid for it, and it was created, but then it was posted on August 30th.
it was created after August the 12th, according
It was
to your
posted.
chronology.
It was posted August the 30th.
All right, that's enough. Thank you, Mr. Weeks.
Thank you.
That's all the questions I have.
Do you have evidence that you
Yes, sir.
want to present?
Yes, sir. Yeah, I'd like to present Exhibit 1, which is some of the information that I already asked Officer Gasson about. Who's going to take it?
Beth, could you
Beth,
get
can you-
that from Mr. Patholinis, please? Thank you, dear.
Right there. Okay, then I have my Exhibit 2 here. Under Ordinance 8-13, it says, "Only city may collect and dispose. All solid waste and residential curbside recyclables accumulated in the city shall be collected, conveyed, and disposed of by the city. No other person shall collect, convey over any of the streets or alleys of the city or dispose of any solid waste or recyclables accumulated in the city."
Hang on just a
Where
second.
does
So
this
wait, so we know. Did you have any objection to either one of those?
Give me just a second, because since I got two, I'm going to look at something really quick. And then I probably will here in just a second. All right, well, my would be the relevance of 8-13, because the definition of waste materials also includes sand, lumber, stone, brick, cement, roofing, and other refuse materials usually left from a construction project. That's one thing. It's a residential customer, which I believe this is a commercial property. And something about an active account, but I'm not going to get into that. But we're not here to discuss 813, so the relevance of City Ordinance 813 would be in question first off. So I would object to it based on its relevance.
What about the first exhibit?
My documents, they're the same ones that I've already presented to the board, so I would have no objection to those.
So you need to decide whether or not you want to accept them. My advice to you, Mr. Chairman, is to accept both into evidence. Mr. Patsoulis is making an argument that, mitigation type argument that he couldn't do it because of the fact that it's not allowed. So I think it's appropriate for you to accept into evidence that copy of the code. Normally, we don't accept code provisions in evidence. We just do what we call judicial notice. We take judicial notice of it. But I don't see any harm in receiving it into evidence, and I would suggest that you do that.
Bobby, would you receive this into evidence when it gets down your way, please?
Yes, sir.
Any other exhibits, Mr. Patsoulis?
Yes, sir.
Okay. How many do you have? Can you just give them all to Beth so she doesn't have to keep walking back and forth?
Okay, and then I can go through them.
How many are there?
7 total, sir.
Okay. Officer Gasson, if you can just look at those other 5 documents and tell us whether or not you have any objection. If not, we'll just move them through the process.
Understood.
Okay.
This is 822, which is already documented in the case, so I have no objection to exhibit number 3. Exhibit number 4 is 8-40. Exhibit number 5 is City Ordinance 8-52. 6-1 and 9-1 are in here. I have no objection. They're completely irrelevant to the case, but we've already kind of established that we'll take some other ordinances, so I have no objection to that. Do you have exhibit number 8 and 9 on here? You want those considered
Oh,
as well?
yes, sir. I'm sorry.
Okay.
There are
So
9
his
total.
chronology, I have no objection to what he thinks occurred. And so there's an email on August 14th from Scott Witt to, I don't know who FLSnewest.aol.com is. Is that you?
Yes, sir.
Okay. So on August 14th, this is the email I sent today requesting an extra pickup. Please schedule an extra pickup as soon as possible. Emails on overloaded dumpster on August 14th.
Those go chronologically backwards. The top page
Oh,
is the
newest to
most
oldest?
recent, and
Okay.
the last page is the earliest.
So apparently at one point in time, there was a car block in the dumpster. They had it moved. So this is just an exchange of emails on or around August 14th with the city and Mr. Patzley. So the city has no objection to that.
Receive them all.
Receive them all into evidence then, Bobby, please,
Yes,
when
sir,
they
I
get
will.
down to you.
Okay, you can proceed, Mr. Patsalides. That's all been received into evidence, 1 through 9.
Okay, 8-22, which you have as an exhibit, again says it shall be unlawful for any person to permit or allow any debris, trash, or rubbish to accumulate or remain upon private property located in the city when the same is hazardous to health, safety, or any of the inhabitants of the city. So I bring this up because and I'll summarize it, but after being notified of what happened, I immediately contacted the city, and they contacted Waste Management, who's the sole source trash picker, and they came out and tried to pick up all the trash and debris. So that's why 822's in there. I won't cover 840 or 852. We've already asked some of those questions. And I'll skip by the other two exhibits as well, and I'll concentrate on my chronology. And I'd like to read that off. And then this is a summary of the city's contacts and my contacts with the city regarding having this pile of stuff that was dumped on my property removed.
Mr. Patsalides, you don't need to read it. It was received into evidence.
Well, I want to emphasize at least one thing, that this process started on August the 6th by me, which was before anyone saw anything or before any complaint was issued, and I contacted the city to have the trash removed. So I initiated this on my own. I was compliant in trying to remove this trash. I did everything I could and followed up all the way through till August the 14th, which was the day that they came and removed the last amount, including calling and getting special pickups over this period of time in order to alleviate all this furniture and trash. So I don't know what else I can do except call the city and then rely on the city to do their job, which they did, but it took them several days to get it done. So if I had the authority to do what Officer Gasson said, hire an outside truck, I could have removed it right away, but I had to follow the procedure as outlined in those statute sections, ordinance sections. The last exhibit is the actual chronology with the city, my calls and what happened, and it would have been done even quicker, except when the city came out, just like I had the sign posted up there, no parking, somebody had parked in front of the dumpster, and so the city's truck could not remove it that day, and I had to address that issue and then call the city back, and then they came the next day and removed the trash again. So I did everything I could to address this issue. I do not feel that I had control other than calling the city and resolving this, and I do not feel that I should be fined in any way or found in violation, since I did everything according to what's outlined by the city regulations and ordinances.
Okay.
I have a couple of questions. You presented 8-13, the only city may collect and dispose, correct? That ordinance to the board? You presented that ordinance, right? As an argument?
Sure, that's my
Okay.
understanding. I've been told that in the past when I tried to hire somebody, and then the city objected and said, I tried to bring in a dumpster, and the city objected to that.
Did you do
the
that in this
past.
case?
Huh?
Did you do that in this case? Did you call
No.
the city? You didn't?
No, sir.
Okay. Because it does state, you read most of the ordinance, except for the very last few words, which says, unless otherwise agreed to by the city. We never got any kind of request to have somebody haul it off or anything. So
No, that's because I didn't even know there was a violation. I didn't even get the violation until August the 16th, which was after everything was completely resolved. Per your exhibit, and you show the post office delivery date, I didn't get it until after I had already resolved everything. Then I got the notice in the mail. So
Okay.
everything had been done by the time I was notified by Tarpon Springs Code Enforcement that I was in violation.
Okay,
So
but-
I did everything on my own.
Absolutely.
Okay, so I just want to establish, you made no effort to ask the city if somebody else could haul it off with your argument. You never called anybody and got any negative or affirmative response.
I was
to-
previously told I
Okay,
couldn't
but
do
not
that.
in this case.
I was previously told I could not
Okay.
do that.
Yes or no?
So I
In this case.
proceeded immediately when I saw the dumping to get
Okay.
it taken care of in the process that I had been told I needed to use. And I called and initiated the process. And again, I think it is important to emphasize that I wasn't even notified from the city, from code enforcement, until after this entire trash and debris was already removed.
All right, another quick question. This is yes or no. Have you been to Code Board before here?
Yes, sir, I have.
Okay. Have you been to Code Board before for, hold on, it's yes or no time. Have you been to Code Board before for violation 8-52? Yes or no?
Officer Gasson, I don't think that's a fair question, and I
Okay,
have
that's fine.
never
I'll
been
scratch that
before the
question.
code board with the prior code
Okay.
enforcement officer,
fine, Mr.
only with you,
Petzler.
sir. You're
Okay.
the one that brings me here every time. None of the others, none of the prior one ever brought me here over the 8 years that she was a or plus 8+ years she was a code enforcement officer.
That's fine. Have you ever been here when Mr. Trask has explained to you that for the next 5 years, you would be considered a repeat violator and you should probably maintain your property? Matter of fact, I believe last code board, Mr. Trask informed you on the record, the city of Tarpon Springs is not your property management company. Do you recall that statement?
I do not, but I
Okay,
do
that's fine.
recall the first statement that you made about being 5 years and maintaining my property, and I do try to maintain my property.
But you do establish that 201 North Pinellas is yours. You own it.
Yes, sir, I do.
Okay. And you, I'm guessing, have some sort of a problem with dumping because you put signs up. I assume you put those signs up.
That is correct.
Okay.
I do have a problem, and as soon as I see it, I clean it up.
Did you ever call the
And
police?
I've not had any prior violations. I've owned that property since 2001, I think.
I'm going to go
And
ahead.
I've never
I
had
just
any
have one last question, I'll be
dumping
done, and I'll be done.
violations
No
ever.
more, sir.
Do you,
Please.
did you call the police for illegal dumping?
I didn't get notified
Yes or
about
no?
it until August the 16th, which was after it was already clean, so there was no need to call the police.
Yes or no? Yes?
Did you call the police?
No, sir, I did not.
How was your attention brought to the trash at the property? How did you become aware of it? Did you drive by? Did somebody call you?
I drove by and saw it.
Okay.
And the waste management people called me to tell me that they couldn't pick up the dumpster because somebody had overloaded it and it was too heavy and it was unsafe to pick up. So they contacted me. The same day they contacted me, I went over there and looked at it. And if you follow the chronology, I even pulled some of the heavy stuff that was sticking out of the dumpster personally, pulled it out and put it in trash cans and removed it from that area so that they could pick up the dumpster. The first day,
Portion of questioning is over. And I would like you to summarize.
I think it's pretty straightforward. We've been here numerous times before for violation of trash. Mr. Patsalias owns the property. He's responsible for the property. There's obviously trash outside the property. There's a violation. We can get into all of the semantics about who picks it up or whatnot. You're responsible to maintain your property. The fact the city is not going to come after you because you decide to clean up trash after your property, that's a little bit unrealistic. Then also there's a provision in an ordinance that he brought up under 813 that says otherwise agreed to by the city. He made no effort to ask the city if he could have somebody else remove it, because if he would have called me and said, can I hire somebody to haul this trash out of here, I would have not said no to him. So it's his responsibility. He is probably more educated on the way the codes work in this city than I would venture to guess most people because of his tenure at this code board. So we continue to rehash the exact same things. Mr. Patsalidas owns it. He's aware of the violations, and the city contends that they existed, and he took a period of time to clean them up, and he was a repeat violator for that period of time. And that's all the city has.
Mr. Patsalinas?
Yes,
Could you
sir.
summarize?
I would
your
like to.
case?
Thank you. Again, I think it's extremely important to understand that I did not even receive this notice of violation until 2 days after the trash had been cleaned up. The only notice I got was from the city waste management telling me that they could not pick up the dumpster because it was overloaded. And immediately I reacted, and that same day after work, I went there and personally removed items and fixed the dumpster so it could be picked up. I didn't even know about these violations that Officer Gasson is talking about, and it's my responsibility. I took my responsibility. As soon as I was notified by the city, I immediately started addressing the issue, and I did it through the process that's required per the city ordinance. And I don't feel that I should be fined or found in violation of this ordinance based on my actions and what I did immediately upon being notified, not by code enforcement, but by the city. And then I worked with the city and through the city to get all the trash and debris removed.
Thank you, sir. Public portion of this case is now closed. The board will entertain a motion.
I move based on testimony, evidence, facts presented in law that the respondent, Mr. Patsalidas, was in violation of sections 8-22, 8-40, 8-52 from, and I'm going to give you 2 days on this, although your testimony waffled on this somewhat. Waste Management was called on the 7th, but the city's not citing you until the 9th, so I'm going to begin my date as the 9th until the compliance date, which is the 16th, so that sets us 9th, 10th,
Compliance
11th,
was the
12th,
14th.
14th, 15th, 16th. That's 7
For the
days.
exhibit, the
Excuse
on
me,
the
sir.
14th.
Excuse me.
Okay. Well, that's why I wanted to
So-
read the exhibits so you could get them correctly, and you told me
No,
not
sir.
to.
The public portion is closed,
Yes, sir.
and we're having a discussion amongst ourselves.
And the compliance was the 16th of August, and a fine of $500 per day for a total of 7 days, and that 7 times 5 is $3,500. In addition, I move that the city be awarded $99 for the costs incurred in prosecuting these cases, and I would also hope that the previous fines would be paid. Thank you.
Second.
Roll call, Bobby?
Yes. Mrs. Tellier?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Patsalidas, you've been found in violation of those 3 code sections, 8-22, 8-40, and 8-52 as a repeat violator under the city code. You've been found in violation for 7 days. You've been fined $500 a day. You've also been ordered to pay prosecution costs of $99. There will be an order entered. It'll be entered within the next 10 days and sent to you in the mail. If you have any questions, you can talk to the code enforcement officer after the meeting.
Thank
I
you.
understand that you have another case later on So petition for rehearing, so if you could stay around for that, there
Yes,
may
sir.
be questions about that.
There's also another one listed on the,
Okay, all right, so please don't leave the room. Thanks.
Mr. Trask, hold on, please, just a second. Looking through this, 8-22 was a new violation. He was not a repeat violator in 822. So that order would not be
sorry, I
correct.
did-
No, that's fine, but I don't want the order to go through as it is because it would be incorrect and we would just have to correct it next month.
Yes.
852 and 840 are repeat violators. He should not be a repeat violator for 852.
820.
Or I'm sorry, 822. I apologize.
Okay, so we need another motion then to correct
I
that.
would like to establish that then, please.
Yeah, 852 and 840 are repeat, 822 is new.
Can I amend that motion, or do we need to revote?
No, you're going to need to amend the motion to remove section 8-22, so he's not fined for that as well.
Thank you.
Yeah.
I move that we amend that motion and remove section 8-22 from my prior motion.
Okay.
Second.
I have a question. Does that mean that the fine does not apply to that new violation?
The
That's
fi-
correct. It's been removed, and so then the way the order would read would be 8-40 and 8-52. So the fine would only be for those two items.
Right.
It would not be for 8-22.
But would it still be the same fine?
I would request the same. If you want to make it a different amount, I'd listen to you.
But what would the time, the same time period?
Same time. Then
Okay, we have a motion and a second on the floor. Bobby, could you go ahead and do a roll call, please, on the amended motion?
Mrs. Tellier? Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Okay, so you may want to go ahead and address 8-22 as a new violation for the purposes of establishing it. But since it's in compliance, there would be no fine.
Correct.
I move based on the testimony, evidence, and facts presented and the law that at the time of the alleged violation, section 8-22 of the Code of Ordinances of the City of Tarpon Springs was in full force and effect. At the time of the notice of violation, the respondents were in violation of said codes, however, are now in compliance.
Second.
Okay. Roll call, Bobby? Thank you.
Mrs. Tellier?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson? Mr. Kramer?
Yes.
Mrs. Dabbs? Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Okay.
On to number 5, 19-800000562, 743 Bayshore Drive, Carol Flanders. You state your name?
Carol Flanders. And it's
Alexander Casatelli.
my husband.
Say, do you want to,
I believe they have exhibits.
what?
They have evidence.
Oh,
Any objections to
any
the
objection
evidence?
to the evidence?
Thank you. Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement, case before the board 19-800000562. Property address is 743 Bayshore Drive, owned by Carol Flanders. This is a repeat violator case. The previous cases were case 19-800000180, violation of the same codes, 8-40 and 8-52. The fine levied at that time by the city was $25 per day, a total of $294, which was paid by the owner. Repeat violator, case number 18-800000662, violation of city codes 8-40 and 8-52. It was complied before the deadline. There was a $50 per day fine assessed if it was not in compliance, and the prosecution costs on that were paid. So all the previous fines have been paid by the owner. Exhibit number 1 going before the board are all the photographs. Exhibit number 2, all my notices, include the notice of violation and notice of hearing. Exhibit 3, administrative docs, case summary, previous board orders, property tax and property appraiser records. Exhibit number 4 is the affidavit of posting and a copy of the sign. Exhibit number 5 is the affidavit of prosecution costs. All the photographs and exhibits that were given to the violator are the exact copies of what's being presented to this board. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearing are sent both return receipt as well as first-class mail. And Mr. Chairman, please accept these exhibits into the record as evidence.
Bobby, when they come down to you, please? We
Yes,
will.
sir.
The code enforcement office had contact with the owner via phone call. The case started out on August 12th, the rear yard being overgrown. Part of the rear patio is falling apart and looks to possibly be a hazard from the complaint from my initial inspection. On August 12th, the repeat violator notice of hearing was mailed. The mail was returned unclaimed. On August 30th, I conducted a reinspection, and based on previous conversations stating that the property was taken care of on August 14th. So on August 30th, I inspected it, and it was in compliance, so we used the compliance date of August 14th for the violation. Posted the property on August 30th, signed the affidavit. As stated, it's a repeat violator for cases, or sections 8-40 and 8-52, and you can see from the photographs, the rear yard was overgrown, and as I stated, when I re-inspected it, it had been taken care of. So they're no longer in violation. So they were a repeat violator for a period of time from August 12th until August 14th. So it was 2 days they were a repeat violator.
Do you have any questions for Officer Gasson?
How did you determine the length of the grass?
It's pretty obvious that it's over a foot. I mean, I think
Did you measure it?
No, I did not, because I couldn't go on your property to trespass it.
We mow that lawn every 7 to 10 days.
Okay?
Tarpon Springs received 22 inches of rain in July, 15 inches in the last week. This is an area which has a low spot, and there is sawgrass which just loves to grow. Every 10 days or so, this is mowed. This is a property that cannot be, that is not visible from the street.
Sir,
There is one individual
Sir.
who calls.
Just questions.
this
sir.
is questions right now,
Okay, I'm
cross-examination.
sorry.
You'll have your opportunity to tell us all of that, but we're just trying to do it the formal
Right.
I'm
process here. So do you have any more questions of the officer? If not, you can proceed with what you're going.
No, sir.
No other questions? Okay. All right, sorry. Go ahead then.
Okay. The second photograph that he had, we had extensive damage from Irma, and we are still in the process of litigating this with the insurance company. They gave us a partial settlement for damage to the roof. However, they've denied, there was the entire property had been fenced in. All of the fencing had been blown down. I'm sure if Officer Gaskin has been there in previous times, he himself can tell you that the improvement in the property is 1,000% over what it is. Particular thing that he said was part of the back porch. We went back there and we secured that. We put a couple of pieces of 2x4 in there. We screwed it in to secure it. It's an area which is not accessible. The house is currently unoccupied, and we are looking to sell the property. So we're doing the maintenance. It's been a couple of months since we've been here, and like I said, we're in there every 7 to 10 days. I have one of my staff take my lawnmower and go over there and mow the lawn, weather permitting. And July was an absolutely terrible month coming to rain. I mean, everybody here, we got soaked. And this property, that one area, just grows and grows and grows.
We're not trying to not be in compliance is what we're trying to tell you.
I understand.
You know, we make every effort to make sure that that property is maintained.
The front of the property, the neighbor just to the south of us is a Pinellas County deputy. We had given him a 1-foot easement on the property so that he could put his trailer in, and in exchange for that, he mows the front lawn all the time. So that the front, as you drove by from the street, because I understand what the officer had said regarding another particular thing that, geez, look at that mess. How would you like that across your house if you were trying to sell it? And we've always kept that in mind. We've cleaned up the property. We've repainted the building, even though, for the purpose of, curb appeal. We're doing our best.
Does the board have any questions for the violator?
I did. I noticed that the house is homesteaded, but you don't live there?
No, it's homesteaded, but The problem is that I had,
The
a
damage.
pipe underneath the foundation had broken. And you see all those Morgan and Morgan commercials about if you've got copper pipes. And
Yeah.
so we are fighting with the insurance company over this, and you can't live in a house without water. But it's still, I go there. I mean, we go there every single day. My mail is there, and so I am in compliance with Homestead. Okay, so that part is in compliance. But there is, right now with the city, the water has, but it was the city that notified me that when they came and said that I went through 70,000 gallons of water.
In like a day and a half.
And I
Yeah, so
had
that-
no idea that I had a problem.
Yeah, they turned it off again. We have a couple of issues going between, with the insurance company. The leak under the slab is
homeowners.
one.
So there's no water to the home, so you can't live there without water. So like I said, Morgan and Morgan keeps on saying if you've got copper pipe. So that's what the issue is with that.
Okay.
So
Any
that's not related to this Irma
No.
claim.
No.
No.
Do you have any questions?
I don't have any questions, no. Thank you, though.
You have summation or
Do you have a summation?
Just very quickly, the board can see by the picture, there's a 3-foot chain link fence. I'm leading towards 2/3 of that 3-foot high fence probably puts the grass somewhere in the 2-foot range. I mean, this is kind of what I have. We've had lots of discussions about trespassing on people's property. Unless the owners of 743 Bayshore give me blanket consent to go in their backyard, I'll be more than happy to take a yardstick with me and measure it every time. Otherwise, this is what I'm presented with, and I believe that it's a fair assumption it's greater than 12 inches in height. So the city has nothing further as far as that. Just the repeat violator for the 2 days for 840 and 852.
All right, I'm going to close the public portion of this and go ahead and entertain a motion.
I move based on the testimony, evidence, facts presented in law that the respondent was in violation of sections 8-40 and 8-52 of the Tarpon Springs City Code from August 12th to August 14th, and a fine of $50 per day for 2 days, or a fine of $100. In addition to that, I move that the city be awarded $69.50 for the costs incurred in prosecuting the case.
Second. First and a second. Roll call, please, Bobby.
Mrs. Tellier,
Yes.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mrs. Dabbs,
Yes.
Ms. Wade,
Yes.
Mr. Weeks.
Yes.
So, Mrs. Flanders, you've been found in violation of those two code sections as a repeat violator, 8-40 and 8-52. You've been found to be in violation from August 12th to August 14th. You've been fined $50 a day. And you've also been ordered to pay prosecution costs of the city of $69.50. That order will be entered in the next 10 days and provided to you by mail at the address listed by the tax collector and property appraiser. If you have any questions about what you need to do or how you need to do it in the future, please contact the code enforcement officer after this meeting. Okay? Thank you.
Repeat violator 19-8000582. It's a vacant lot on Island Drive, parcel 12/27/15/533/52/003/0100. GSD Investments, LLC.
Anyone here for that case? Thank you.
Okay.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case before the... Burp.
Yes, sir?
I live on that street,
Oh.
and I was just a concerned citizen.
Okay.
I wanted to come and put my input.
Okay, that's up to the city.
It's up to the city, and we recognize that you're here, and we recognize your concern. Okay, if you can have a seat and see what the city wants to do next. I'm sorry.
That's okay. As I stated, case number 19-800000582. This is a vacant lot on Island Drive in the corner of Hill Street, down at the end of the Sponge Docks. Property is owned by an investment company, GSD Investments LLC. It is a repeat violator case. That was from a 2016 case, 2016 8-00000604, violation of City Code 8-52 and 13302. At the time, a fine was levied by the city at $100 per day. There is a total of $74,510 that are still unpaid on that property. Exhibit number 1 going before the board are all of the photos. Exhibit number 2 are all the notices, to include notice of violation and notice of hearing. Administrative documents, case summary, previous board orders, and property appraiser and tax collector records are exhibit number 3. Exhibit number 4 is the affidavit of posting and a copy of the sign. Exhibit number 5 is the affidavit of prosecution costs. All my notices are mailed to the property owner of record based upon the Pinellas County Property Appraiser and Tax Collector databases. All my notice of violations and notice of hearings are sent, return receipt requested, as well as first-class mail. And Mr. Chairman, please accept these into the record as evidence.
Bobby, when they get down to you, please accept them into evidence.
Yes, sir.
We haven't had contact specifically with the owner. We had contact with the company that was hired to clean up the lot. The case started on August 27th, 2019, when I conducted my initial inspection. As I stated, it's a vacant lot on the northeast corner of Hill Street and Island Drive. Previously, this lot was completely mowed. It is greater than 10,000 square feet, but since it's been previously mowed, it's the same property owner. The requirements will continually to be mowed. And it wasn't on this date, and if you saw the pictures going around, or I can put them up on the board, you can clearly tell that the property hadn't been maintained. The notice of violation, notice of hearing, repeat violator, notice of hearing were all mailed. The mail was returned signed. On August 30th, I posted the property with an affidavit of posting also signed. On September 12th, I conducted the final inspection. It was in compliance. The maintenance company stated the lawn was cut on 9/5, and the vines and everything for the violation of 133 were removed on 9/9. So I guess ultimately the final compliance date would be 9/9 for everything. The city codes that were in violation were 8-40, 8-52, and 13302, applicability and maintenance of trees. The vines are growing up into the trees, and what that does is eventually those vines will kill off any of the trees. So that ordinance covers that. He was previously cited for the same ordinance. And as I stated, however the board wants to entertain it, the maintenance company cut the yard on 9/5, but removed the vines on 9/9. Since they're all wrapped up into the same case, 9/9 would be the final compliance date. Interesting note, we received a phone call from the maintenance company that was hired to take care of the property, and they went out and said somebody already mowed the property. So it got taken care of by somebody. We just don't know who, because apparently it wasn't the actual maintenance company that got hired to take care of the property. But it is in compliance as of now. So it was, again, repeat violator, August 27th to September 9th. And that's all the city has at this time.
Any questions from the board? Questions from the board, close the public portion of the, and we'll entertain a motion.
Let's separate the two so I don't make that mistake again. We're going to propose the new violation first. I move that based on testimony, evidence, and facts presented in law, that at the time of the alleged violation, Section 8-40 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Roll call, Bobby?
Mrs. Tellier?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Yes. Mrs. Wade?
Yes?
Mr. Weeks?
Yes.
And regarding that motion, I move that the respondent shall, it is in compliance now. So then we're going to,
Yes, he is in compliance. Sorry about that. I was looking at the previous case.
We should have probably added that on to the other motions.
Yes.
So what my suggestion is
should
that
read,
you amend the
and it is
motion to
currently in
reflect that.
compliance.
Amend the motion to reflect that it is in compliance and there's no fine.
Regarding the other two issues,
I'm sorry, we need to do that.
We have to do that.
we can't just add
We need
it
to
on.
amend that other motion, so
And
So you okay with the
I'm
amendment?
amended it to, and it is currently in compliance.
Good.
Okay.
Can I have a second?
Second.
Bobby, roll call, please.
Okay. Mrs. Tilliard?
Yes.
Mrs. Norfleet?
Yes.
Ms. Norfleet?
she said yes.
Yes.
Oh, I'm sorry, didn't hear that.
Okay.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Ms. Wade?
Yeah.
Mr. Weeks?
Yeah.
Okay, so we need the
On the
second motion.
repeat violation. What?
We just need that second motion, I was
Yeah,
saying the
second
repeat,
motion.
okay.
So on the repeat,
On the repeat violations, I move that based on the testimony, evidence, facts presented in law, that the respondent, GSD Investments, was in violation of sections 8-52 and 133.02 of the City of Tarpon Springs Code from the date of 8/27 until its compliance date of 9/9 of 2019, and a fine of $250 per day for the 12 days. In addition, I move that the city be awarded $91.50 for the cost incurred in prosecuting the case.
Second.
roll call, Bobby?
Mrs. Tilliard?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Wade?
Yes.
Mr. Weeks?
Yes. Affidavits of non-compliance?
Is there anyone here in this case, 1306 Crossbow Lane? Yes?
19-8000077, 1306 Crossbow Lane, Edward and Margaret Carmichael.
Carmichael.
Your names, please?
Your names
Margaret Carmichael. I'm the owner of the property.
and your sir?
Michael C. Sunderman, son-in-law.
Son-in-law.
He lives there.
Okay, this is a case that's coming back to determine whether or not you're in compliance within the current code. We're not going to rehear the case all over again. So the code enforcement officer is going to testify and submit into evidence an affidavit of noncompliance that you are not in compliance with that property, and then you'll have the opportunity to discuss that.
Thank you. Officer Steve Gasson, City of Tarpon Springs Code Enforcement. Case before the board is an affidavit of noncompliance for case 19-800000077 for 1306 Crossbow Lane. The affidavit of noncompliance is for one city code 40.00, and the board date for compliance was August 15th of 2019. And upon inspection of the property after that date, there was still a violation of that city code. And that's basically it. It did later come into compliance, so we'll be hearing, I think we might be hearing an affidavit of compliance for the same property next month. So, and that's all the city has at this point.
Any questions that the board has of Officer Gasson?
I'm confused.
Yeah, me too.
So it was not in compliance within the time that you had ordered. It has since been brought into compliance. So you're to determine on this affidavit of noncompliance that's being presented to you, did they come into compliance within the time that you ordered? And if they did not come into compliance within that time frame, you need to accept the affidavit of compliance.
Non-compliance.
Or, I'm sorry, noncompliance. So
On all the items?
No, just on the one.
Just 40.00 of the case. Everything else came into compliance prior to the board ordered date. Normally,
Okay,
we
doesn't
don't
say
discuss
that.
these, they're just accepted. So, and on the board order date of August 15th, City Code 40.00 was not in compliance.
Okay.
Okay, she has the opportunity to.
You have an opportunity to just let us know whether you're in compliance or not in, and why you think
I
so?
feel that we were I'm sorry, Michael Sonderman. I feel that we were in compliance. I was told that the cars had to run, have insurance, and registration, and I have proof here of both vehicles with insurance. On the 15th, I have the picture of the vehicle in the street. They were running. And he's going to show a picture where the one vehicle was locked in four-wheel drive. So I disconnected the front drive shaft there, and that's what he has a picture of. But I do have pictures of them with insurance, registration. There's a picture, if you zoom that in, there's a tag, registration sitting on the car.
Well, I'm looking at this vehicle with the drive shaft hanging out. I'm
Yeah,
pretty confident you can't drive it.
Locked. It was locked in.
But it's not operable. On August 29th,
It is
not
operable. Oh, I forgot I left it down.
Okay. I mean,
all I had to do was tie it up.
you couldn't jump in and drive it away the condition that it was in. So that's why I'm here saying that
Yes.
you're not in compliance on that date.
Right, right, pictures.
And then I believe they were towed away and brought
That
into
one,
compliance.
we end up having that one towed away
Okay.
because it locked up.
So, because it wasn't operable.
It ran. It ran.
Okay.
Started up.
I thought we had until you came out and re-inspected, and that was the day the fine would start. I was totally
The
unaware.
board ordered date of August 15th.
Yeah, I had no idea that it was being, or I would have taken care of the situation.
Okay. Any questions by the board? No questions. Close this portion of the meeting and entertain a motion by the board or maybe questions you have afterward.
So this would just be a motion to accept the affidavit of noncompliance or not.
I move based on the testimony, evidence, and facts presented in law that the respondent failed to timely comply with the board's prior order within the tribe time prescribed and award the city $164 for the costs incurred in the prosecuting of this case.
Second, please.
Second.
Thank you. Bobby, roll call?
Mrs. Telliar?
Yes.
Mrs. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Wade?
Yes.
I'm sorry, I missed Mrs. Dabbs. I apologize. Thank you. Mrs. Wade, please?
Yes.
And Mr. Weeks?
Yes.
Thank you.
Okay, so just to summarize then, although you're in compliance with section 6-1 and 105.1 and 8-52, you are not in compliance with section 40.00 as of the compliance date of August 15th. I understand that you have been since then, and that will come up. That affidavit will be considered by the Code Enforcement Board next month. So the Code Enforcement Board has awarded prosecution costs in the case of $164. There'll be an order entered. It'll be entered within the next 10 days and provided to you at the address listed by the tax collector and the property appraiser's office. If you have any questions, you can contact Code Enforcement after the meeting. Okay? Thank you.
Thank you.
And if I can just make a mention, Bobby, this affidavit of non-compliance is coming down to you.
Oh, sure.
There was a separate motion that was made, and so the affidavit of non-compliance was not accepted, but there was a motion finding non-compliance. Okay? So
Okay.
we're handing that down to you. Okay.
Thank you. Affidavits of compliance.
And Mr. Chairman, I'm sorry.
Where do I pay that?
So my suggestion is you wait till the order comes in, and you can pay it at the clerk's office, which is the building just outside the door here. Okay?
And that letter will get to you within 10 days.
Yes. Okay.
Mr. Chair, I was just going to let you know in the 5 affidavits of compliance, only one of them has affidavit, or I'm sorry, prosecution costs, just to make it easier on those other 4.
Maybe someone do all the other four at one time, Mr. Kramer.
Beautiful.
Kramer to do that.
Well, he usually reads the case number.
Okay. 18-8000086.
I move we accept the affidavit of compliance in that case.
Second.
You can do it by voice
All those
vote.
in favor say aye.
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 Same opposed. Vote carries. 18-800000470.
I move we accept the affidavit of compliance in that case number.
Second.
Second.
All those in favor say aye.
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 All those opposed.
I'm sorry, I'm not hearing the second.
Ms. North.
Thank
Ms.
you.
Norton. All those opposed, same sign. Motion carries. 19-800000014.
I move we accept the affidavit of compliance in that case and award the city $162 in prosecution costs.
Second.
All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. 19-800000151.
I move we accept the affidavit of compliance in that case.
Second, please.
Second.
All those in favor say aye.
Aye.
All those opposed, same sign. 19-800000332.
What happened? Oh, I'm sorry. I move we accept the affidavit of compliance in that case.
Second.
All those in favor say aye.
Aye.
All those opposed, same sign. Okay. Now we're getting to old business.
Yeah, this first item is a petition for rehearing. If you don't mind, I'd like to read you the rule that is in your rules of procedure, since this doesn't happen very often. So I'm going to read Rule 5, Section 3. Any aggrieved party may petition the board to reconsider or rehear any board order resulting from public hearing. This petition must be made in writing and filed with the board secretary no later than 30 days after the execution of the order and prior to the filing of any appeal. Upon receipt of the petition, the board will consider whether or not to reconsider or rehear the case. A motion to approve a petition to reconsider or rehear must be made by a board member who previously voted on the prevailing side. A motion to approve a petition to reconsider or rehear a case must set the date and time for the rehearing. The rehearing may be held at the time of the consideration of the petition if the petitioner and all other parties agree. The board will not hear oral argument or evidence in determining whether to grant the petition to reconsider or rehear. So with that being said, that you have a packet of materials that you would have received. It's Mr. Patzelides' motion for, our petition for rehearing, along with a number of attachments. And then you also have the city's response to the petition for rehearing. And so you need to determine, based upon your rule and your review of these two documents and the exhibits, whether or not you want to grant that petition for rehearing. If you do, we'll make a second motion, and that would be to set the date and time after we talk to Mr. Patzelides and city staff to see whether or not that they want to proceed on it today.
Just so I'm clear, one of us has to make the motion to agree to rehear.
That's correct. There needs to be a motion either way. So either it would be a motion to grant the petition for rehearing or a motion to deny the petition for rehearing.
Thank you.
I'm ready for a motion.
I move that we deny the petition for a rehearing.
Second.
Discussion.
Discussion?
Packet of things to look at.
I'm sorry, we can't hear you.
There was a considerable amount of evidence that was submitted to us. We were given a lot of time to look at it and go through it. Most of us have been here when those initial rulings were made.
It's been, any other discussion before I forget it?
Well, I further think we've done diligence on these cases. I think we've done our job. I don't think a rehearing is gonna change any of our feelings.
Do you want to say something down there?
No, I agree that we've done due diligence and that all of the things that have been presented, we have rehashed thoroughly. And that there's nothing new that's been presented that would change our opinion.
I want to make sure everybody feels that way, so we're going to vote on this.
Okay, we have a motion and a second. Bobby, would you do a roll call, please?
Mrs. Tellier?
Yes.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs? Ms. Wade?
Yes.
Mr. Weeks?
Yes.
Okay, so the petition for rehearing has been denied.
Okay, no, 14, fine reduction request, 18-8, 0000470, 606 North Pinellas Ave.
And if I can, I'd like to go ahead and read that because there's a lot of people in the audience, let them know what we're doing here today. So I'm going to be reading the rule on that. Rule 5, Section 4, different than that last rule. After a fine has been imposed by the board and within 60 days after the violation is brought into compliance, a violator may petition for reconsideration of a fine. The petition must be in writing, signed by the violator, and include a copy of the affidavit of compliance executed by the code inspector. The petition must include conclusive evidence showing extreme or undue hardship in the payment of the fine or preventing the violator to come into compliance within the time period established by the board's order. The board secretary shall schedule the petition to be considered, and the board shall make its determination based solely upon the written petition. The board may request information from the code inspector. The board secretary shall notify the violator by regular mail of the determination made by the board. No petition for the reduction of a fine will be considered prior to the board's acceptance of an affidavit of compliance. Under no circumstances may the amount of the fine be reduced below the cost of the action. Under no circumstances may the amount of the fine be reduced once a foreclosure action is instituted. Additionally, under no circumstances may the amount of the fine for a repeat violation be reduced. That's a reading of your rule dealing with fine reduction requests.
Has this been complied with, Officer Gaston?
I'm sorry?
Has this been complied with?
Yes, it is, and the property owners are here.
That was in your packets, so I'm sure you've read all the information in reference to it. At this time, I'll entertain a motion.
Can I ask a question? Bobby, can you tell us the total dollar amount of the fine right now? Was that listed in the city's response?
$43,360.
I'm sorry, could you repeat it again?
$43,367.
Okay, that's a little bit different than what has been listed by Code Enforcement Department. They've listed $46,677.50.
My fine began on, October 31st, 2018. I had an affidavit signed on August 15th of 2019. That is at $150 per day. That is $43,200 plus the $167.50 was awarded for prosecution costs.
Thank you. That's the number that you should rely upon. That's the number that the city clerk's office, the billing department would use.
Can you confirm that total, please?
$43,367.
50 cents.
And 50 cents, I'm sorry.
I make a motion that we decline the application for fine reduction.
Second.
Bobby, roll call, please.
Excuse me, I'm not sure I heard her. Did she say to deny it?
Yes.
Thank
Any discussion, though?
I'm sorry, any discussion by anyone? Okay, Roll call, Bob? Bobby?
Mrs. Tillier,
Yes.
Mrs. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Wade?
Yes.
Mr. Weeks?
Yes.
Okay, so that petition for reduction of fine has been denied.
Okay. Any approval of minutes? We don't have any minutes yet, did we, Bobby?
No, sir.
Okay. Public comment. Anybody have any public comments they'd like to say? You just,
Can't be in any case that was heard today.
right. Okay. Board or staff comments? Okay. It's adjourned. Thank you very much for your participation, everyone. Thanks to the staff of